Under Article 2, Section 712 of the Uniform Commercial Code, or UCC, a buyer of goods may cover a seller's breach of contract by purchasing reasonable goods in substitution for those due. In addition, a buyer may recover damages for the difference between the cost of cover and the contract price, plus incidental or consequential damages, but less expenses saved. But what if the contract is a services contract? May the purchaser of the services recover damages for cover? The Federal Circuit Court of Appeals considered this question in Hughes Communications Galaxy versus United States. In December of 1985, Hughes Communications, a satellite internet service provider, contracted with the National Aeronautics and Space Administration, or NASA. Under the contract, NASA was to launch Hughes's HS-393 satellites on NASA space shuttles until either 10 satellites were launched or until September 30, 1994, whichever was earlier. In January of 1986, the Space Shuttle Challenger exploded. NASA then stopped launching commercial satellites on shuttles. After 1986, Hughes launched 3 of its HS-393 satellites on expendable launch vehicles, or ELVs, instead of shuttles. In addition, Hughes launched 6 of its HS-601 satellites on ELVs. The HS-601 satellites were similar to the HS-393 satellites, but were more powerful and better suited for ELV launches. Subsequently, Hughes sued the United States government in federal claims court for breach of contract and for an illegal taking under the Fifth Amendment. After granting Hughes summary judgment on its breach of contract claim, the court held a damages trial. At trial, Hughes sought to prove damages for its cost of cover by showing its increased costs in launching 10 satellites on ELVs instead of shuttles. The government provided evidence that the HS-601 satellites wouldn't have been developed absent the government's breach. In addition, a government report showed that NASA could have only launched 5 HS-393 satellites during the contract period using its best efforts. The court then calculated Hughes's costs of cover based on the costs of launching the 3 HS-393 satellites on ELVs, plus the average cost of those satellites for the 2 other satellites that NASA could have launched. Both parties appealed to the Federal Circuit.